Real party in interest. Who is a real party in interest? A real party in interest is the party who stands to be benefited or injured by the judgment in the suit, or the party entitled to the avails of the suit. So the rule is, unless otherwise authorized by law or the rules of court, every action must be prosecuted or defended in the name of the real party in interest. Okay? So this rule, again, every action must be prosecuted or defended in the name of the real party in interest. There are two requirements for this rule. First, to institute an action, the plaintiff must be the real party in interest. And second, the action must be prosecuted in the name of the real party in interest. Okay, when you say interest, what interest is required? Interest, within the meaning of the rules of court, means material interest or an interest in issue to be affected by the decree or judgment of the case, as distinguished from mere curiosity about the question involved. One having no material interest cannot invoke the jurisdiction of the court as the plaintiff in an action. What are the purposes of the real party in interest rule? Necessarily, the purposes of the provision are, number one, to prevent the prosecution of actions by persons without any right, title, or interest in the case. Number two, to require that the actual party entitled to legal relief be the one to prosecute the action. Number three, to avoid multiplicity of suits. And number four, to discourage litigation and keep it within certain bounds pursuant to public policy. Let's discuss the case of HBD Partners Holdings Incorporated versus Med Central Incorporated. This is a recent case, 2017. Petitioner MCI is a domestic corporation. In 2008, the owners and stockholders of MCI decided to sell their shares in the business. Isa Amor Sarmiento was appointed by MCI as its attorney-in-fact to negotiate with potential buyers. Dr. Hernando Delizo was interested, who claimed to represent Healthcare Business Development Partners Holdings Incorporated, or HBD. A memorandum of agreement was entered into by and between HBD and MCI. HBD reneged on its obligation to pay the agreed installments. HBD, through Delizo, filed a complaint against respondents for the return of 3 million pesos as partial payment of the purchase price of MCI's business and shares. Respondents filed a motion to dismiss on the ground of failure to state cause of action, since petitioner HBD is not a real party in interest, since it is not a party to the memorandum of agreement, and HBD came to existence only a month after the execution of the memorandum of agreement. Isa filed a separate motion to dismiss, alleging that she is not a stockholder of MCI and does not have any interest in the memorandum of agreement. So the RTC denied the motion to dismiss. The Court of Appeals, however, dismissed the complaint against Isa for being merely a representative of MCI and against the stockholders of MCI. The issue in this case is whether Isa was a real party in interest. The Supreme Court held that first, there is no dispute that HBD's cause of action is based on the memorandum of agreement. HBD's complaint praised for, among others, the confirmation of the rescission of the memorandum of agreement, and as a necessary consequence of such rescission, the return of 3 million pesos as partial payment for the purchase of MCI's business. The MOA was executed only by and between HBD and MCI. Clearly, only HBD and MCI are the parties to the MOA. The parties' respective rights and obligations arise out of the MOA and are governed by its terms. Therefore, persons who stand to be benefited or injured by the judgment in the suit, the real parties in interest, are the parties to the contract, namely, HBD and MCI. Correct. ISA signed the MOA as a representative of MCI. Meanwhile, the respondent MCI stockholders are not parties to the MOA. Consequently, ISA and the respondent stockholders are not real parties in interest in HBD's suit against MCI. Therefore, the complaint should be dismissed against them for failure to state a cause of action. Further, the Supreme Court held that if a suit is not brought in the name of or against the real party in interest, a motion to dismiss may be filed on the ground that the complaint states no cause of action. What happens when the plaintiff is not the real party in interest? If a suit is not brought in the name of or against the real party in interest, a motion to dismiss may be filed on the ground, what ground? That the complaint states no cause of action. However, the dismissal on this ground entails an examination of whether the parties presently pleaded are interested in the outcome of the litigation and not whether all persons interested in such outcome are actually pleaded. The latter query is relevant in discussions concerning indispensable and necessary parties, but not in discussions concerning real parties in interest. Both indispensable and necessary parties are considered as real parties in interest, since both classes of parties stand to be benefited or injured by the judgment of the suit.